All right, you guys ready to start?
Do it.
Yep.
Yes.
Yes,
All
Chairman.
right, well, good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public?
Morning, Commissioners. No, we have no public comment this morning.
Thank you very much, sir. Good morning, Ms. Miller.
Good morning, sir.
How are you today?
I'm doing very well.
Well, good. Let's tackle this agenda. How about that?
Yes, sir.
If we'll start with agenda item 3, except we don't have any cases to reconsider under agenda item 3. Is that correct?
That's correct, sir. No cases.
Well, then we'll jump right into agenda item 4 and consider tax liability cases. We have no tax cases on docket 51, 2 cases on docket 52, and 1 case on docket 1.
Yes, sir. That's correct. So on docket 52, beginning with case TD-20-077-0620, Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez.
I maintain my previous dissent.
Yes, sir. And Mr. Chairman.
I agree with staff recommendation.
Thank you. The second case on docket 52 is TD-20-085-0820. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
And the case pulled on docket 1 is TD-20-097-1120. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you.
We have no fair housing cases under agenda item 5.
That's correct.
So we'll move to agenda item 6, where we have 1 wage claim case on docket 51, no cases for docket 52, and 1 case on docket 1 that have been pulled for additional discussion.
Yes, sir, that's correct. On docket 51, it's case number 19-057-293-5. Commissioner Demerson,
The employer's motion for rehearing should be granted. The record indicates that the original hearing officer may have missed certain relevant information pertaining to the claimant's work hours and leave time usage. The MR includes an affidavit from the claimant regarding a former coworker, and the facts in the affidavit differ in some important respects from other evidence given by the claimant with regard to the time worked and time missed from work. There are also some text messages that could be relevant to the merits of the wage claim. If taken into consideration at another hearing, since it appears that important evidence exists that has not yet been considered, I believe a rehearing is necessary. Accordingly, we should grant the employer's motion to rehear and hold a rehearing to obtain additional testimony and documentary evidence on the claimant's work hours and leave time.
The motion to rehear should be denied. The employer offers a heavily redacted affidavit from the claimant regarding hours worked and some statements about overtime. The claimant was awarded wages based upon unpaid salary. Details about precise hours worked and overtime were not the basis of the prior decision. The evidence offered by the employer, to the extent it may be new, would not change the outcome of this case. With regard to the employer evidence of monthly timesheets showing hours charged vacation leave, the employer at all times had these documents in its possession and has failed to provide a compelling reason for not providing this evidence sooner. The motion to rehear should be denied.
Grant the motion for rehearing.
thank you. The case pulled for docket 1 is case number 19-060-260-5. Commissioner Alvarez,
Let me get it. In her appeal, the claimant stated she has provided new address and explained that she has been unable to change her address because things have been shut down due to the pandemic. The claimant's appeal period was during the height of the pandemic when TWC services were most in use and contacting the agency was most difficult. The claimant has provided a reasonable explanation for why she was unable to change her address. The claimant's appeal should be deemed timely and the case remanded. Deemed timely and remand.
We should dismiss the claimant's wage claim appealed to the commission as late. The claimant did not allege delayed receipt or non-receipt of the WCAT 2 decision nor was the decision returned to the agency as undeliverable. While the first half of the appeal period fell during the window of time the TWC was experiencing technical difficulties, the second half did not. Thus, because the claimant's appeal was filed 30 days late, there is no credible and persuasive evidence to rebut the presumption of receipt, and there is no good cause exception to the timeliness rules. We must dismiss the claimant's appeal to the commission as late and leave the underlying WCAT2 decision in full force and effect.
Timely wage claim commission appeal resubmit.
All right, we have a majority vote that the appeal is timely. Commissioner Alvarez voted to remand the case, and Mr. Chairman, you voted to resubmit the case. We need to decide whether it's going to stay at the commission appeals level or go back down to the lower level.
Ms. Miller, I would agree to a resubmit as well.
All right.
Good.
All right, that is the last pulled wage claim case for these three dockets. I did send you the short form dissent list for the wage claims a moment ago.
I move we accept staff recommendations on the remaining wage claim cases on dockets 51, 52, and 1.
I second the motion except for those cases on which I'm dissenting, as reflected on the wage claim short form dissent list for docket 51, 52, and docket 1.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the wage claim short form dissent list for docket 51, 52, and 1.
Motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 51. Please proceed when you're ready.
Yes, sir. Before we start, I just wanted to give you commissioners and staff who are listening a heads up that shortly before the docket meeting this morning, it was pointed out that there are two cases, one on docket 52 and one on docket 1, where a supplemental summary was requested by a commission office, but it wasn't distributed. So when we get to those two cases, I'm going to request at that time that those be resubmitted on a future docket so we can provide the requested supplemental summary. But there wasn't time for me to contact all of you beforehand, so I just wanted to give you that heads up now.
Thank you.
First case number, please.
2589562, Commissioner Dimerson.
The AT decision should be reversed. The claimant, a substitute teacher, resigned when he failed to seek and accept new assignments. According to the employer's undisputed testimony, the claimant could accept assignments online or by phone if he wanted to work. Moreover, further work was available to the claimant after his last assignment ended. Thus, the claimant initiated the job separation when he failed to avail himself of further work, and there's no evidence that the claimant had good cause for quitting. As such, we should reverse the AT decision, reimburse the employer, not bill.
The decision should be affirmed. As a substitute, the claimant worked on call as needed. Therefore, he was laid off due to a lack of work at the end of his last assignment. Such a job separation was not disqualifying. Accordingly, the employer's account should be billed. Affirm the AT bill reimbursing employer.
Reverse the AT, reimbursing employer, not bill.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2599448, Commissioner Alvarez.
The decision is not supportable. The claimant is a diabetic and at a higher risk for serious illness should he contact COVID-19. The employer was not requiring masks to be worn, and individuals at work had contacted the virus. As such, the claimant had good cause to quit, and the employer's account should be protected from charge due to the disaster. Reverse the AT valid claim, no voluntary leaving, no chargeback, disaster.
That the AT decision should be modified. I agree that the claimant separation was the result of the disaster. Accordingly, we should modify the AT decision, no voluntary leaving, no chargeback, disaster, sever the validity of claim issue.
Modify the AT valid claim, no voluntary leaving, no chargeback.
Thank you. We have a unanimous decision.
Case number 2609050, Commissioner Dimerson.
The appeal tribunal decision should be modified. I agree that the claimant filed a valid claim. On the job separation, the claimant was paid her normal wages to the end of the school year and was given a letter of reasonable assurance. However, the employer provided additional correspondence establishing that the claimant declined the letter of reasonable assurance. Since the employer provided the claimant a letter of reasonable assurance, thereby indicating a desire for the employment relationship to continue, the claimant's rejection of the reasonable assurance letter was the equivalent of voluntary quitting without work-connected good cause. We should therefore modify the AT decision, valid claim, voluntary leaving.
A determination was issued on March 26, 2020, that granted the claimant benefits. A subsequent job separation determination was issued, but not within the 14 days. Therefore, UIO and CS was without authority to issue the April 28, 2020 job separation and overpayment determinations, and those determinations were void. The employer's response was a timely appeal to the March 26 determination. The claimant was separated when she was sent home due to her own personal illness and later learned that she needed to be quarantined due to being in contact with someone who had COVID-19. The claimant did not have access to a test at the time. As the claimant was separated due to her own personal illness, she should be qualified for benefits. Set aside AT decision, void April 28, 2020 job separation and overpayment determinations, and modify the March 26, 2020 determinations, no voluntary leaving, MVI, and void chargeback.
A quick question, Ms. Miller, Commissioner Alvarez, on that case, can you go over the docket number again to make sure that we're all on the same page with this?
Yes, sir.
Okay.
This is case number 2609050.
Okay, I pulled out the wrong one. I apologize for that. Okay, I got it. Thank you for that. The AT decision is correct and should be affirmed. The claimant was not working or earning wages when she filed her claim during the summer. She therefore filed a valid claim as an unemployed individual. Regarding the job separation issue, the claimant stopped working and earning wages when there were no more work available from the employer after the school term ended. She was therefore involuntarily separated for reasons that were not misconduct connected with the work. The fact that the claimant had reasonable assurance to return to work in the following school year term does not change the nature of the separation issue. Reasonable assurance is essentially the same as a return to work date of a temporarily laid off worker. And Commission Precedent clearly holds that the employee temporarily laid off for more than 3 business days is involuntarily separated from non-disqualifying reasons. Reasonable assurance is only relevant in determining whether the claimant's wages from educational institutions should be suppressed, which is not the issue in this case. Affirm the AT valid claim, no misconduct.
Affirm the AT, valid claim, no misconduct.
Clerk Warren?
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2615913, Commissioner Alvarez.
The decision is not supportable. The claimant stopped working because of COVID-19. The claimant lives with 2 high-risk individuals, including her 81-year-old grandmother. Additionally, the claimant testified that there was a lack of COVID-19 training, sanitation, and hot water at work, which the employer did not refute. As members of the claimant's household were at high risk for a serious illness should they contact COVID-19, the claimant had good cause to quit. Since the claimant's separation was a result of the disaster, it would be appropriate to protect the employer's account from charge. Modify the AT valid claim, no voluntary leaving, no chargeback, disaster, no overpayment.
The AT decision should be modified. The claimant's testimony is problematic because her witness was coaching her throughout the hearing in an apparent attempt to remove the claimant's disqualification from benefits. Thus, the claimant's allegations are unpersuasive, and the employer's credible testimony established that the claimant did not address any concerns prior to resigning. Consequently, the claimant quit without good cause connected with the work, and we should modify the AT decision. Voluntary leaving, no chargeback, overpayment of $1,900, and sever the validity of the claim issue.
Affirm the AT, valid claim, voluntary leaving, no chargeback, overpayment.
Commissioner Alvarez, do you have a
Yes,
dissent?
short form dissent on this case.
Yes, sir. And I also want to make a note on the validity of claim issue. Only one of the commissioners voted to sever this. It's perfectly fine to affirm it. Commissioner Dimerson, if you agree with that then you'll have the same vote as the chairman.
Okay, yeah, that's fine. Severability of the claim issue. We're good.
Okay, we will not
Okay.
sever it. We will simply affirm it.
Okay, that's fine. Thank you.
Thank you.
Case number 2616235. Commissioner Dimerson.
We should reverse the appeal tribunal decision. The employer's representative did not receive the wage verification notice until after the deadline to appeal had passed. Although the mail was checked daily, delays with the mail service during the pandemic seemed to have caused the delayed delivery. Because the witness's testimony of delayed receipt was corroborated by the received date stamp on the document, the employer had presented credible and persuasive evidence to rebut the presumption of timely receipt. Accordingly, because the employer filed its appeal only 3 days after receipt of the wage verification, we should reverse the AT decision, deem the employer's appeal timely, and resubmit for merits testimony.
Ms. Miller, can I hear what Commissioner Demerson's, what his result was, his deem, what he would like on this case?
The note that I have on Commissioner Demerson's vote is reverse the AT, deem employer's appeal timely, and resubmit.
Perfect. I'll agree to that.
Okay,
Agreed.
thank you. We have unanimous decision.
Case number 2626752. Commissioner Alvarez.
The appeal tribunal found that the claimant was ineligible for benefits for an open period beginning July 5th, 2020, because the claimant was unwilling to work due to COVID. In her appeal to the commission, the claimant clearly states that she has accepted the realities of COVID, has and will take steps to ensure her health and safety, and is willing to work. As such, the claimant's ineligibility should be closed as of the date she informed the commission of her willingness to work despite the pandemic. Modify the AT claimant not available, modify the AT claimant not available for work July 5th, 2020 to November 7th, 2020.
The AT decision should be affirmed. The claimant testified that she was not willing to return to work until the virus was contained. Since the claimant's circumstances have not changed, I would not agree to close the open period of ineligibility. Because the current record shows that the claimant restricted her availability for full-time work, we should affirm the AT decision, claimant unavailable for work beginning July 5th, 2020.
Affirm the AT, claimant not available for beginning July 5th, 2020.
Commissioner Alvarez?
I'm sorry, I'm having a little difficult time on hearing. What was that? Chairman, what was that again?
Yeah. Flip back to that page. Affirm the AT, claimant not available for work beginning July 5th, 2020.
Okay, great. Short form dissent?
Yes, sir.
Case number 2630343. Commissioner Alvarez.
The AT decision is not supportable. The AT decision concluded that the claimant had the burden to disprove the employer's allegations and failed to do so. Since the claimant was discharged, the employer has the burden to prove that the claimant was discharged for misconduct connected with the work, and the employer failed to meet that burden. The employer's witness in the AT hearing was an HR representative who was hired after the claimant's separation and had no substantive information about the separation. The claimant denied that he was absent on the final day of employment, as alleged by the employer's witness. The employer did not meet its burden to establish any misconduct by credible and persuasive evidence. In the alternative, I would also agree to a rehear in this case. The record in the AT hearing was not well developed. No information was provided about why the claimant was absent or tardy on the final incident. The hearing officer failed to ask the claimant any substantive questions about the reasons for his final attendance infraction. Rehear the case.
I'm sorry, Commissioner Demerson. Commissioner Alvarez, I didn't get your primary vote. You said reverse the AT. I didn't hear that. I just want to be clarified because you presented the rehearing as an alternative vote. So I just want to clarify your primary vote.
Yes, reverse, no misconduct chargeback.
Thank you very much. Commissioner Demerson?
Okay, the appeal tribunal decision should be affirmed. The employer presented the more credible evidence, which established the claimant was a no-call, no-show before his final day of work. The claimant acknowledged he had received prior warnings about his absenteeism and tardiness. As such, the claimant's actions constituted work-connected misconduct, and we should affirm the AT decision. Misconduct, no chargeback.
From the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2633176, Commissioner Alvarez.
The AT decision should be reversed. The claimant left her employment when she agreed to a temporary leave of absence package so that the employer would not have to lay off employees. The claimant agreed to the temporary leave because she has an elderly husband and a mother with health conditions that make them vulnerable to severe illness from COVID-19. Additionally, the employer was not following CDC guidelines regarding social distancing and refused to provide face masks to employees. The claimant had good cause connected with the work to leave her employment temporarily as a result of the pandemic. Additionally, since the separation was as a result of the disaster, the employer's account should be not charged. Modify the AT, no voluntary leaving, no chargeback due to disaster.
The appeal tribunal decision should be affirmed. The claimant voluntarily decided to avail herself of the employer's voluntary leave of absence plan. Had the claimant not done so, it does not appear that she would have been imminently discharged by the employer. It also does not appear that the claimant afforded the employer an adequate opportunity to address her workforce concerns. Accordingly, the claimant's resignation was without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Modify the AT, no voluntary leaving, no chargeback disaster. Let's do a memo to UIO and CS to investigate possible unreported earnings.
Chair, I agree.
Okay, we have a unanimous decision. No voluntary leaving, no chargeback, disaster impacted, and memo to UIOCS for possible unreported earnings.
Case number 2641384, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The employer laid off the claimant due to lack of work caused by the COVID-19 natural disaster. This was not a simple layoff resulting from general economic conditions. As such, because the job separation resulted from the COVID-19 disaster, the employer's account should be protected from charge. We should reverse the AT decision, no chargeback.
Ms. Miller, I would agree with Commissioner Dimerson.
I agree.
Thank you. We have a unanimous decision.
Case number 2642349, Commissioner Alvarez.
The decision is not supportable. The Commission has previously found that customary full-time hours was a validity of claim issue entitled to the timeliness exception in Rule 32I1. Accordingly, claimant appeals should be deemed timely and the case resubmitted for merits. Deemed timely and resubmit.
Claimant filed a late appeal. However, since the underlying issue in this case deals with customary full-time hours, which could be identified as a validity of claim issue, we should find the claimant's appeal timely under the one-time exception to the timeliness rules found in Rule 815.32I1 and resubmit.
Reverse the AT, time of claimant appeal, resubmit.
Thank you. We have a unanimous decision.
Case number 2653507, Commissioner Alvarez.
The decision is not supportable. It appears the claimant was at least partially unemployed when she filed her claim. Regarding the separation, the claimant is 73 years old and has an underlying health condition. She is at higher risk for serious illness should she contact COVID. As such, the claimant had good cause to quit and the employer's account should be protected from charge due to the disaster. Reverse the AT, valid claim, no voluntary leaving, no chargeback disaster, and void adequate response.
The appeal tribunal decision should be modified. I agree the claim is valid. As to the job separation, the claimant quit her job due to fear of COVID-19. However, the claimant did not offer a doctor's opinion on her ability to work or other risks. It also does not appear as though the claimant offered the employer an opportunity to address her concerns. Accordingly, the claimant quit without work-connected good cause. We should modify the AT decision, valid claim, voluntary leaving, no chargeback, sever adequate response.
Modify the AT, valid claim, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2653531, Commissioner Alvarez.
The decision is not supportable. The claimant worked as an at-home reservationist. The employer notified the claimant that her department was being shut down and that if she wished to continue employment, she would need to work in the office full-time. At that time, the employer also offered the claimant a benefit package should she retire. As her department was being shut down and continued work would have required working full-time in the office, there was a substantial change in the claimant's job which she had good cause not to accept. In accordance with Commission Precedent, as the claimant was unable to continue her job and would lose the available benefits should she not accept the package, the claimant's acceptance of the benefit package in retirement was not disqualifying. Reverse the AT, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. The claimant chose to accept the final financial incentive of more than $33,000 rather than continue working for the employer while work was still available. In addition, the claimant testified that she was eligible for retirement and that her primary reason for leaving was because it felt like a good time to go. Since the claimant quit her job for a personal reason, she quit without work good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2665305, Commissioner Alvarez.
The decision should be modified. No misconduct, tax governmental employer. The claimant was discharged for poor performance. However, the employer testified that the claimant never consistently met the employer's standards. The claimant testified that she was working to the best of her ability, and the employer failed to provide any evidence to the contrary. Additionally, unlike the precedent cited by the AT, the claimant's job as a chemist is not simple. As such, in line with Commission precedent, the claimant's inability to meet the employer's standards, despite the best of her efforts, is not misconduct. Modify the AT, no misconduct, tax governmental employer.
We should affirm the appeal tribunal decision because the claimant's work performance failed to improve after multiple counseling sessions and additional training. The claimant mismanaged her position of employment. Accordingly, we should affirm the AT decision, misconduct, federal employer.
Modify the AT, no misconduct, void reimbursement ruling.
Short form.
Yes, sir. And let me clarify on this one. The employer is a federal employer, so tax governmental does not apply. Therefore, we have a majority vote that the claimant is not disqualified. But I need a vote on the chargeback determination, which in this case for the federal employer is not appropriate. The chairman has voided it. In order to void it, I need another vote to void or some other instruction on what to do with that.
Ms. Miller, I would agree with the chairman's vote.
Thank you very much.
Yes, ma'am.
Case number 2667135, Commissioner Dimerson.
We should reverse the appeal tribunal decision. Under section 205.0125 of the Act, a reimbursing employer will not be billed if an employee quit without good cause connected with work. A claimant's qualification for benefits is not the standard by which the statute measures a reimbursing employer's liability. Here, although the claimant's job separation meets one of the enumerated exceptions to disqualification under section 207.045, it does not mean that the claimant had good cause connected with work for quitting. The claimant quit one job to accept another. This is a personal reason for quitting and not good cause connected with the work. Therefore, because there is no evidence that the claimant had good cause to quit, and in accordance with the statute, the employer should not be liable for benefits paid to the claimant. We should reverse the AT decision, reimbursing employer not billed.
The decision should be affirmed. The claimant was working part-time on call as needed. The claimant accepted full-time work that increased her weekly pay. With the new job, the claimant was no longer considered partially unemployed. Such a job separation is non-disqualifying, and therefore the employer should be billed. Affirm the AT, bill reimbursing employer.
Reverse the AT, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2667906, Commissioner Alvarez.
The decision is not supportable. As a result of the pandemic, the claimant's workload was drastically reduced. Although the employer was able to provide some PPP money to their employees, it only accounted for 75% of their employees' average earnings. For the week of her initial claim, the claimant received $334.45 in total pay. The claimant's weekly benefit amount was $521, which is 125% of which is $651.25. As the claimant was paid less than 125% of her weekly benefit amount and working less than her normal full-time hours, she was partially unemployed and her claim is valid. As the claim is valid, the overpayment ruling should be reversed. Reverse the AT, valid claim, no overpayment.
Although it appears that the claimant's earnings during the week she filed her initial claim were high enough to where she could not be considered either fully or partially unemployed, she may be eligible for a backdating of her initial claim to the week before that, when her earnings from work were so low that she could have been considered totally unemployed. The backdating issue would need to be investigated by the UI division, and so we should send a memo regarding that issue. Thirdly, we should affirm the AT decision. The claimant's initial claim on April 5th, 2020 was invalid. Overpayment of $1,911, and send a memo to the UIO and CS regarding whether the claimant's initial claim can be backdated to the previous week when her earnings were significantly lower.
Reverse the AT, valid claim, no overpayment, memo to UIO and CS to investigate possible unreported earnings.
In a short form.
Yes, sir, Commissioner Demerson.
Thank you.
I have your short form dissent, and we'll send a memo about possible unreported earnings. And that is the last pulled case on docket 51. I did send the short form dissent list for the UI cases on docket 51 earlier during the meeting.
Move we accept staff recommendations on the remaining UI cases on docket 51.
I second the motion except for those cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 51.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 51.
The motion passes with the exceptions noted.
Thank you. Moving on to docket 52.
Case number 2568733, Commissioner Alvarez.
Thank you. Sorry about that. The claimant's appeal should be deemed timely. The claimant testified that the decision was delivered the day of the deadline. It is unreasonable to expect someone to instantly appeal a decision or determination that was delivered late. Parties are given a 14-day deadline to appeal so that they have a reasonable amount of time to take action. The claimant took a reasonable amount of time to read the decision and decide to appeal. Deem timely and resubmit.
The claimant's CA appeal should be dismissed as late. Inconsistent and contradictory testimony regarding his experience appealing the AT decision. As such, his testimony on that issue is neither credible nor persuasive. What is clear, however, is that the claimant appeal was filed beyond the deadline to do so. And there are no good cause exceptions to the timeliness rules. We should dismiss the claimant's CA appeal as late and leave the underlying AT decision in full force and effect. Valid claim, voluntary leaving, void the no chargeback ruling, and overpayment.
Dismiss the commission appeal as late. The AT decision remains in full force and effect.
Commissioner Alvarez, do you have a dissent?
Yes, ma'am. Short form dissent.
Yes, sir, I have that.
Case number 2569588, Commissioner Dimerson.
Let me find that one. AT decision should be modified. The job separation in this case occurred when the claimant went out on indefinite medical leave due to her pregnancy. Since the claimant had to stop working due to medically verified illness, she should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. Accordingly, we should modify the AT decision, valid claim, no voluntary leaving, no chargeback, MVI.
Ms. Miller, I would agree to Commissioner Demerson's decision.
Thank you.
Agreed.
Thank you. We have a unanimous decision.
Case number 2584021, Commissioner Alvarez.
The AT decision is not supportable. The claimant was given a severance package by the employer upon the claimant's work separation pursuant to the Employee Protection Plan that the employer set up during the employer's bankruptcy proceedings in September of 2017. The plan was implemented to encourage employees to remain employed by the employer even though their offices were shut down during the bankruptcy. The claimant complied with the terms of the agreement by remaining employed by the employer throughout its bankruptcy shutdown and was separated years later. The claimant accepted the offered agreement from the employer by complying with the terms of the agreement and continuing in his employment. The severance package was therefore part of the negotiated agreement prior to the separation and is not disqualifying under Section 207.049 of the Act. Reverse AAT severance pay eligible.
The commission should grant a rehearing in this case. The employer's appeal document contained information about specifics relating to the claimant's severance payment. The employer also stated that its representative was unable to attend the hearing due to a death in the family. As such, we should hold a rehearing to allow the employer's representative to participate and also to confront both parties about the nature of the claimant's severance payment.
Reverse the AT, no severance disqualification.
A short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2593143, Commissioner Dimerson.
The appeal tribunal decision should be reversed. When the claimant's last assignment ended, there was work available for her per the employer's testimony. The claimant, a substitute teacher, dictated her own schedule and could choose to accept assignment via the employer's online system or telephone system. Since the claimant stopped accepting assignments when assignments were available to accept, she quit without work-connected good cause, and the employer should not be billed. We should therefore reverse the AT decision, reimburse an employer not billed.
The decision is supportable. The claimant performed services for the employer in April and May of 2019. The employer continued to make jobs available to the claimant until the end of May 2019, when the school year ended. The claimant was separated at that time. There is no indication that the claimant quit or that the employer considered the claimant to have quit prior to the end of the school year. Since the claimant's separation was not for misconduct connected with the work, the employer's account should be billed. Affirm the AT bill reimbursing employer.
Reverse the AT, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2597464, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant worked as a substitute teacher and the employer testified that the assignments are made available to all substitute teachers who can view the available position online and assign themselves on a first-come, first-served basis. After the claimant finished her last assignment, there was further work available. Since further work was available for the claimant, the subsequent job separation was a voluntary quit without work-connected good cause. We should therefore reverse the AT decision, reimburse an employer not billed.
The decision is supportable. The evidence indicates the claimant was an on-call as needed employee. No evidence has been presented to establish the claimant was aware of when her next shift would be at the conclusion of her shift. Therefore, in accordance with Appeal Number 212-CA-77, the claimant was involuntarily separated for reasons other than misconduct. As the claimant's separation for reasons other than misconduct, the employer's account should be billed. Affirm the AT bill reimbursing employer.
Reverse the AT, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2605326, Commissioner Dimerson.
The commission should grant a rehearing in this case. The claimant failed to intervene when a client was pushed down to the ground by another staff member. The allegations against the claimant were confirmed by an investigative report. As such, the claimant's inaction would rise to the level of misconduct connected with the work. However, before that determination can be made, we should conduct a rehearing in order to develop the record on the employment status of the staff worker who allegedly pushed down the client.
The claimant was discharged for failing to intervene between a client and another staff member. The claimant was unaware at the time of the incident that the client was pushed. The claimant believed the client had merely fallen and did not believe physical intervention was warranted. The claimant had only recently begun working with patients and was not prepared for client's behavior. The claimant's inaction was not misconduct connected with the work. Modify the AT, no misconduct, bill reimbursed an employer, sever valid claim issue.
Reverse the AT. Misconduct, employer not billed, adequate employer response, sever validity of claim issue.
Short form dissent.
I'm going to agree with the chairman, Chair.
Yes, sir. We do have a majority vote. And Commissioner Alvarez, I have your dissent.
Case number 2606031, Commissioner Alvarez.
The decision should be reversed. The employer failed to provide testimony and evidence. The claimant provided the testimony that she failed an audit, but no details were provided to the claimant. She is unable to rebut the allegations because the employer has presented no factual basis for the conclusion that she failed. The claimant had some prior warnings, but her performance was not an issue until the new supervisor was hired. Consistent with Appeal Number 87-06368-10-041787, the employer's changed perception of what constitutes adequate job performance by a new supervisor does not constitute misconduct on the part of the claimant. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant had received warnings pertaining to her performance, and she was aware of the employer's disciplinary process. Since the claimant continued to make errors in her work despite receiving warnings, her actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, charge.
Fair point.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2612536, Commissioner Dimerson.
The appeal tribunal decision should be modified. I agree the claim is valid. As to the job separation, the claimant resigned due to allegedly being shown inappropriate videos on a cell phone by his manager. However, the employer presented a firsthand witness, the general service manager, who testified that the claimant went to resign after he was told to remember to properly clock out for lunches. In addition, the employer's payroll manager stated that she had not heard of any of the claimant's allegations before the day he resigned. The employer also presented one of the claimant's coworkers as a witness, who stated that the manager in question never showed the coworker any appropriate videos, nor did the coworker ever hear the manager speak in a derogatory manner towards women. Furthermore, the employer presented the manager in question as a witness, who testified that he never showed the claimant inappropriate video on his phone, and he didn't speak negatively about female coworkers. The claimant did not go to HR with his concerns. In sum, the claimant did not allow the employer an adequate opportunity to address his concerns, and he was not able to establish that his working conditions were intolerable. Accordingly, he quit without work-connected good cause. We should therefore modify the AT decision, valid claim, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant filed a valid claim. Regarding the job separation, several of the employer's witnesses changed their testimony during the hearing or provided contradictory testimony concerning when the claimant complained and type of phone that the claimant's manager had. Due to these issues, the employer's witnesses are not credible, and the claimant's testimony carries greater weight. The claimant's manager continued to show the claimant pornographic videos at work and engage in other inappropriate conduct. The claimant complied, but the issues continued. Therefore, the claimant had good cause to quit. Affirm the AT valid claim, no voluntary leaving chargeback.
Affirm the AT valid claim, no voluntary leaving chargeback.
Commissioner Dimerson, did you short form dissent that one?
I did, short form.
Thank you.
Thank you.
Case number 2619172, Commissioner Alvarez.
The AT decision is not supportable. The claimant first tried to file an initial claim for unemployment benefits in the week of March 22nd, 2020. But due to the overwhelming number of calls received by the commission, he was unable to reach a staff member to file his claim until August, despite diligent and regular attempts to contact the commission. It is common knowledge that the commission has been extremely difficult to contact due to the number of people trying to call since the COVID-19 pandemic started. The claimant established adequate cause for his initial claim to be backdated. Reverse the AT valid claim backdated to March 22nd, 2020.
The AT decision is supportable to a certain extent, but since the claimant offered credible testimony about problems getting through on the phone to TWC for a protracted period of time, I could support allowing the claimant to backdate his initial claim to the end of the high call volume period that was established by the UI division, but not support backdating the claim before that date. Since the claimant's testimony about calling several times a day for months after the high call volume period ended lacked credibility and specifically as to which numbers he tried to call, accordingly, we should modify the AT decision. The claimant filed a valid initial claim, but allow backdating of the claim to the end of the high call volume period as determined by the UI division.
Reverse the AT, backdate the claim to March 22nd, 2020.
We're going to shorten.
Yes, sir, Commissioner Dimerson, I have your short form dissent.
Thank you.
Case number 2624516, Commissioner Alvarez.
The AT decision is not supportable. The claimant had legitimate complaints and obligations about the workplace due to COVID-19. The employer admitted that it was not following the COVID-19 precaution recommendations from its accrediting agency. The claimant also credibly testified that the employees were reusing single-use gloves and wearing the same mask for weeks at a time. One of the employer's doctors insisted that the patients continued with a sleep test after the patient vomited. The employer held a meeting over these and other employee concerns, and then the claimant was directed to sign a summary of the meeting. However, the document did not indicate whether the claimant's signature constituted an agreement with the accuracy summary or acquiescence to the employer's practices. The claimant had no prior disciplinary history and had been employed with the employer for a substantial period of time. The employer's insistence that the claimant sign the meeting summary and the acknowledgement of the employer's policies to which she had already agreed was not reasonable, and the claimant's refusal did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant was asked to sign an attestation form agreeing to adhere to company policy and procedures. The claimant refused to do so because she wanted to revise the form. The claimant was asked repeatedly to sign the form and should have known that doing so was a condition of continued employment. In addition, the employer testified that the claimant was aware that if she did not sign the form, she would be discharged. Still, the claimant did not sign the form. As such, the claimant's actions constituted work-connected misconduct, and we should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Ms. Miller, I'd like to long form this case.
Yes, sir, Commissioner Alvarez, I have a long form dissent.
Case number 2636108, Commissioner Alvarez.
The decision should be reversed. At the employer's request, the claimant changed her schedule to 19 hours of on-time a month, on-call time a month. The claimant continued to be paid during this time. As the claimant's hours were reduced and she was moved to an on-call status at the employer's request, the claimant became partially unemployed under non-disqualifying circumstances. She should be qualified for benefits. Reverse the AT, no voluntary leaving, no overpayment.
The appeal tribunal decision to reaffirm the claimant elected to participate in the employer's voluntary leave of absence program. The claimant stated that she could continue to work, but felt the employer was not taking proper safety precautions. However, there is no indication that the claimant afforded the employer an adequate opportunity to address her concerns. Since the claimant opted to participate in the employer's voluntary leave program while continuing work was available to her, she quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, overpayment of $6,374.
From the AT, voluntary leaving overpayment.
Short form dissent.
All right, thank you. I have the majority vote to affirm the AT. I just wanted to make one note, Commissioner Demerson. My notes differ on the dollar amount. Would you agree with allowing UIONCS to determine the correct overpayment amount?
Yeah, we actually have what about 6,734?
Yes, sir, that agrees with my notes.
Okay, that's fine. Thank you.
Okay, and Commissioner Alvarez, I have your short form dissent.
Yes, ma'am.
Now,
Case number, oh,
I'm sorry to interrupt. This is case number 2645406. This is one of the two cases that I'm going to request to be allowed to resubmit to you because a supplemental summary which was requested by a commission office was not provided in a timely manner. So we'd like to provide that supplemental summary to all of the commission offices and request that you reconsider this case on a future docket. Commissioner, Chairman?
No objection.
I'm okay with that as well.
Thank you very much. I appreciate it.
okay, case number 2663189, Commissioner Dimerson.
We should void the reimbursement ruling. The employer is currently being billed for benefits paid on a fraudulent claim. It's not a case of a claimant who, while working for the employer, inadvertently or intentionally misrepresented information about his claim to the agency. This is a case where the identity of one of the employer's employees was stolen and used in an unemployment claim. Not only did the employer alert TWC to the identity theft, but we also received an email from the claimant stating that he did not file for unemployment. Benefits were paid out to someone who did not work for the employer and who, for all intent and purposes, was a stranger with no employment history with the employer. Understand that the employee whose identity was stolen did not separate from the employer, and that under statute, if there has been no job separation, a reimbursing employer will not be billed for benefits paid to that employee for an unemployment claim. What I do not understand is how the employer is being billed for benefits paid to a malfeasor, a person who has no legal relationship with the employer covered under the Texas Unemployment Compensation Act. I do not believe that the law intended to hold an employer financially liable for criminal acts perpetrated on our agency. For these reasons, we should void the employer's reimbursing liability. If my fellow commissioners have doubts, we should then hold the case pending guidance from the Office of the General Counsel regarding a reimbursing employer's liability under these circumstances.
We should hold this case pending an investigation into the employer's allegations.
The tortured legal analysis in this case does not support billing an employer for a claim that is invalid on its face. The claimant never stopped working. There's no evidence the claimant ever received benefits. So the employer cannot have elected to reimburse the commission for any fraudulent payments made. Void the reimbursement rule.
I agree with the chairman.
Yes, sir. Commissioner Alvarez?
Short form dissent.
Yes, sir. I'll mark that dissent. And the majority vote is to void the RB ruling.
Case number 2680640, Commissioner Alvarez.
The decision should be reversed. The claimant was unable to work from home because he lacked childcare due to COVID. The claimant has 2 toddlers. The claimant was unable to find childcare for them because of people concerned with COVID. The claimant separated due to the inability to work and maintain a quiet environment due to the children being home. When a cousin moved nearby and was able to provide care for the children, the claimant returned full-time work with his former employer. The evidence is sufficient to establish that the claimant lacked childcare due to the pandemic. Reverse the AT-PUA eligible.
The AT decision is supportable. Although I have great sympathy for anyone trying to work during these difficult times of the pandemic, the claimant's testimony and other statements regarding the circumstances of his work separation have been too inconsistent and contradictory to constitute credible proof that his work separation was related to the pandemic. The claimant has at times stated both that he was discharged and that he quit, and he was inconsistent on the number of children he had at home and whether they were or were not in school during the summer. Regarding the reason or reasons for being discharged, he explained that the company gave him the wrong equipment for working at home, that he could not find childcare for his children, that he missed too much work, and that he had too much noise going on at the house. It's difficult to reconcile the various explanations. Accordingly, we should affirm the AT decision. The claimant is ineligible for pandemic unemployment assistance. In the alternative, I could support holding a rehearing to obtain the employer's testimony regarding the circumstances of the claimant's work separation.
Reverse the AT. Claimant is eligible for pandemic unemployment assistance. And memo to UIO and CS to investigate backdating the claimant's PUA claim to July 12, 2020.
Short form, Chair.
Yes, sir, Commissioner Demerson. I have your short form. We will send a memo to investigate backdating to July 12th, 2020. And that is the last pulled case on docket 52. I did send the UI short form dissent list earlier during the meeting.
I move we accept staff recommendations on the remaining UI cases on docket 52.
I second the motion except for those cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 52.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 52.
The motion passes with the exceptions noted.
Thank you. Proceeding to docket 1.
Case number 253-5641, Commissioner Dimerson.
The AT decision is fully supportable. The documentary evidence in this case establishes that the claimant viewed the employer's attendance policy. That policy notified the claimant that a no-call, no-show occurs when an absent employee fails to notify the manager in advance of the absence. The attendance policy also stated that a no-call, no-show can lead to termination. The employer's testimony indicates that the claimant's work schedule was from 7 a.m. to 3 p.m., and the record establishes that the claimant did not call in to report her final absences until after her scheduled shifts were set to begin. Since the claimant admitted that she was a no-call, no-show under policy, and since the policy put her on notice that she could be terminated for her inaction, misconduct was established. We should modify the AT decision, misconduct, no chargeback, server adequate response.
The AT decision should be reversed. The claimant was discharged after she was absent from work because her sister was in a serious car accident. The claimant's sister was admitted to the hospital after the accident, where she later died. The claimant notified the employer of her first absence on that same day and also told her supervisor at the time that she would be absent on the following day as well. Even though the claimant did not call the employer before the start of her shift, her actions did not constitute misconduct because the claimant had an unforeseeable emergency and personal tragedy. Reverse the AT, no misconduct, chargeback, void adequate response ruling.
Reverse the AT, no misconduct, chargeback, void adequate response.
Short form, Chair.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2560791, Commissioner Alvarez.
The claimant has provided sworn testimony that she received misinformation from a TWC representative, which resulted in her failure to appeal on time. The claimant's testimony was consistent with her appeal submitted to the commission. As the claimant received misinformation, the appeal should be deemed timely and the case resubmitted for merits. Deem claimant appeal timely and resubmit for merits.
The claimant received the AT decision in a timely manner, but nevertheless filed her appeal after the deadline had passed. The claimant's allegations of being misled by a hearing representative are not credible since there are no notes in the TWC that corroborate the claimant's assertions, and the name of the representative the claimant provided does not exist in the agency directory. Thus, we should dismiss the claimant's appeal to the commission as late and leave the underlying decisions in full force and effect.
Timely commission appeal, resubmit.
We will resubmit the case.
Case number 2578520, Commissioner Alvarez.
The decision is not supportable. The claimant testified that she normally worked during the summer. The claimant's wage records also reflect that she normally worked during the summertime. The record is incomplete on this issue. Rehear. If my fellow commissioners do not agree that the record should be developed regarding the claimant's normal summer schedule, both parties testified under oath that the claimant returned to work on August 12th. There is no need to waste commission resources on further investigation as to when the wage suppression should be closed. The period reasonable assurance should be closed on August 15th of 2020.
The AT decision should be modified. The parties agreed that the claimant had reasonable assurance to return to work for the employer in the following school year, and the claimant did return to work for the employer in the fall. Thus, the conclusion that the claimant had reasonable assurance is proper. However, since the claimant has since returned to work, the ineligibility should be closed on the Saturday following the date the claimant returned to work. We should therefore modify the AT decision. The claimant had reasonable assurance from May 3rd, 2020 through August 15th, 2020.
Rehear.
All right, it appears that we have, one moment, let me just double check my notes here. We have a majority vote to close the ineligibility effective August 15th, 2020. I only have one, I'm sorry, I had noted an additional vote for rehear, but I believe that is incorrect. Commissioner Alvarez, did your vote include any rehearing?
Yes, it did.
Okay, well then that was actually correct. So I have a majority vote, two inconsistent majority votes then. I have majority vote to rehear the case and also a majority vote to affirm and close the ineligibility.
As of August 15, 2020.
Yes, sir.
Perfect.
Do you want to do both of those things?
I would prefer the rehear, ma'am. Agreeing with the chairman on this.
Okay. Mr. Chairman, any comments?
On the rehear,
Right, as to,
to get evidence of the letter of reasonable assurance and to develop the record on whether the claimant worked or was paid contracted hours and dates after spring break and after returning in the fall.
yes, sir. Commissioner Demerson, do you have any comments?
I'm good. I think we're fine. We're moving in the right direction.
Okay, then I'm documenting that we have both a majority vote to close the ineligibility effective August 15th, 2020, and a rehearing to develop that issue. I'm sorry, it's just very unusual to have two majority votes that appear to be somewhat inconsistent.
Yes, I know that my reasonable assurance was to close on August 15th. I don't know if that makes any clarification.
Basically, I need to know which majority, if I
So
will
here-
go ahead and proceed with both of these if there is no further comment.
So Ms. Miller, let's agree to close the reasonable assurance and no rehearing.
So
With
you
you.
withdraw your vote for rehearing, Commissioner
Yes, ma'am.
Alvarez?
Yes, ma'am.
Okay, so the majority vote is that there was reasonable assurance from March 3rd, 2020 to August 15th, 2020.
Yes, ma'am.
And that's all, no rehearing.
That's correct.
All right. Commissioner Demerson or Chairman Daniel, any further comment on this one?
None.
Okay. Chairman Daniel, if you don't dissent on this, it will be marked as a majority vote. Do you want to dissent?
Short form dissent.
Yes, sir. My apologies for the complications. This case is now concluded. And moving to the next case, the fourth case is 2584806. This is the second case that I request to be allowed to resubmit on a future docket because the supplemental summary requested by Commission Office was not delivered to the Commission offices in a timely fashion. Commissioner Alvarez,
I'm okay with that.
Commissioner Dimerson,
A-okay with it.
and Mr. Chairman,
No objection.
thank you so much, gentlemen.
Yes, ma'am.
Moving on to the next case, please.
2599378, Commissioner Alvarez.
The decision is not supportable. The claimant is the only party to testify, and her sworn testimony should be given the greatest weight. The claimant was informed she had been discharged after missing 2 days with notice. The claimant was not aware of any policies she violated and had not received any warnings regarding her attendance. The employer has not provided any evidence of misconduct. Alternatively, since the claimant does not appear to have been asked regarding the reason for her absences, I could agree to rehear this case to determine the nature of the absences, modify the AT valid claim, no voluntary leaving, void chargeback.
We should affirm the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the claimant stopped reporting for work while work was still available due to family issues. Although the claimant alleged she was fired over text messages, produced the message to support her allegation. Thus, because the claimant initiated the job separation for personal reasons, she quit without good cause connected with the work. We should affirm the AT decision, valid claim, voluntary leaving, void chargeback.
Modify the AT, valid claim, no misconduct, void chargeback.
All right. We have a majority vote to grant benefits to the claimant, however, different rationales. Commissioner Alvarez, you had voted no voluntary leaving, and the chairman voted no misconduct. We do need to choose one of the rationales for the decision.
I would agree with the chairman's decision.
All right.
Short form.
I appreciate that very much, gentlemen. I have your short form dissent, Commissioner Dimerson.
Thank you.
Case number 2605055, Commissioner Alvarez.
The decision is not supportable. Prior to her resignation, the claimant and others went to management about her manager's behavior. An investigation was conducted during which the manager pressured the claimant to discuss the investigation and made threatening statements. The claimant reported the manager's actions. The claimant had been working at home since March due to the pandemic. As soon as the investigation concluded in May, the claimant's manager ordered her to immediately return to the office. The claimant's manager was aware the claimant did not have childcare due to the pandemic. The claimant reported the request to management, but was only contacted by their attorney advising that they would not contest her UI claim. Although the employer appeared for the hearing, they chose not to rebut the claimant's testimony, provide an explanation for why the claimant was requested to return to the office, or why they did not address the manager's order. As such, the claimant had good cause connected with the work to quit. Reverse the AT, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. The claimant gives several reasons for quitting, most of which are based on secondhand hearsay and speculation. Ultimately, the final incident which led to the claimant's decision to quit ensures reasonable request that the claimant return to work at the office. By quitting due to the lack of childcare and without first bringing her concerns to the employer prior to quitting, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Correction, and also, Ms. Miller, if I could have a memo to PUA eligibility.
Yes, sir. We'll add a memo to investigate PUA eligibility.
Thank you, ma'am.
Case number 2606911, Commissioner Alvarez.
The decision should be modified. The claimant has stage 3 kidney disease. Under normal circumstances, this disease does not prevent the claimant from working. The claimant's doctor advised her that she was greater risk of developing severe illness due to COVID-19. Because the claimant worked with customers, the claimant accepted a temporary layoff due to the disaster. Modify the AT, valid claim, no voluntary leaving, no chargeback disaster.
We should affirm the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, she chose to take a leave of absence while work was still available to her due to fear of COVID-19. At the time the claimant quit, she stated she was physically able to work and her doctor had not advised her to quit. Furthermore, there is no evidence that the employer failed to follow the health and safety guidelines. Therefore, because the claimant quit for personal reasons, we should affirm the AT decision, valid claim, voluntary leaving, and no chargeback.
Modify the AT, valid claim, no voluntary leaving, no chargeback disaster.
I agree with the disaster. I agree with the disaster.
Thank you. We have a unanimous decision. No voluntary leaving, no chargeback disaster, valid claim.
Case number 2616220, Commissioner Dimerson.
The commission should grant a rehearing in this case. The claimant was separated from the employer when he transferred his hours to one of the employer's other work locations. The record was not developed as to which party initiated the request for the transfer. If the claimant requested it, then he would be responsible for the job separation in this case. Thus, the record requires further development on this issue, as it would be inappropriate to penalize the employer for accommodating a claimant's request to transfer. As such, we should rehear this case for testimony regarding which party requested the transfer and why the request was made.
The AT decision should be affirmed. The claimant was transferred to a different branch and a different employer account number because the employer needed more dental hygienists at the other branch. She was therefore separated from her employment with the employer. Commission precedent has long held that an employer is subject to chargeback when the employer initiates an employee transfer from one employer account to a different employer account under the same management. This is what happened in this case. Affirm the AT, charge the employer's account.
Reverse the AT, no chargeback.
Short form dissent.
Yeah, I agree with the chairman.
Majority vote is to reverse the AT, no chargeback. And Commissioner Alvarez, I do have your short form dissent.
Thank you, ma'am.
Case number 2623089, Commissioner Dimerson.
The AT decision should be affirmed, but under a different rationale. The claimant was working as a PRN employee at the time she stopped performing services for pay. Per commission president, the job separation in this case occurred when the claimant's PRN shift concluded, since she did not know at the time when her next shift would occur. While this scenario would usually be viewed as a layoff, it was the claimant in this case who elected to change her status to PRN because she was moving. Thus, any periods of unemployment are attributable to the claimant. And since the claimant's request to go PRN was for personal reasons, she quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
The decision should be reversed. The claimant was granted time off from work, but was not offered further work after the end of her leave. The employer's HR director testified that the employer's policy requires the employer to notify an employee in writing 14 days before they are removed from the system and labeled as a quit. The employer did not send this notice to the claimant. As the employer did not follow their own attendance policy, the employer has not shown misconduct, and the claimant should be qualified for benefits. Reverse the AT, no misconduct, chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2624570, Commissioner Alvarez.
The decision is not supportable. The claimant quit work to protect individuals in his home from COVID-19 exposure. The claimant lives with his parents who have underlying health issues that make them a greater risk for serious illness should they contact COVID-19. The claimant worked in a sales position which required him to frequently travel out of the country. There was no work from home options available. Since the claimant quit due to the disaster, he should be qualified for benefits. Reverse AT, no voluntary leaving, void chargeback.
We should affirm the appeal tribunal decision. While the claimant had a compelling personal reason for quitting his job, it did not constitute good cause connected with the work. Accordingly, we should affirm the AT decision, voluntary leaving, void chargeback.
Affirm the AT, voluntary leaving, void chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2625434, Commissioner Alvarez.
The decision should be reversed. The claimant quit because the employer failed to pay overtime as required by the FLSA. The claimant was a level 1 technician. The computer exemption applies to highly skilled workers, such as a system analysis, programmers, and software engineers. The employer testified that the claimant had no technical support skills when he was hired. Additionally, the claimant was paid at an hourly rate below the amount required for a computer employee exemption under FLSA. There is no evidence that any of the other FLSA exemptions applied to the claimant. The claimant was not an exempt employee. The claimant confronted the employer over his failure to pay overtime, and the employer continued to refuse to pay overtime. The claimant had good cause connected with the work when the employer refused to pay overtime as required. Reverse AT, no voluntary leaving chargeback.
We should affirm the appeal tribunal decision. We do not have enough information to determine if the claimant's job duties met the FLSA guidelines for salary and exempt employees. What we do have is the claimant's testimony that he quit on the same day that he had a phone call with the employer about his pay. Because the claimant did not afford the employer a reasonable amount of time to address his concerns before quitting, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2626929, Commissioner Alvarez.
The decision is not supportable. The determination on appeal was provided to the claimant electronically. At the time of the determination was issued, the claimant had not activated electronic correspondence. Determination should have been mailed via U.S. Postal Service until the claimant activated electronic correspondence. Because the determination was not properly mailed, the claimant's appeal should be deemed timely and remand.
We should affirm the appeal tribunal decision because the claimant filed his appeal almost 2 months late and there is no good cause exception to the timeliness rules. We do not have jurisdiction to consider the underlying merits. We should affirm the AT decision. The claimant filed a late appeal, misconduct, no chargeback.
Reverse the AT, timely claimant appeal, remand.
Short form.
Yes, sir, Commissioner Demerson, I have your dissent.
Thank you.
Case number 2628788, Commissioner Alvarez.
The decision is not supportable. The claimant is the only party to testify, and he has provided a corroborating witness. The employer only provided an internally inconsistent statement, which the claimant rebutted. The claimant's sworn testimony and that of his illness should be given greater weight. The claimant stopped working when he began to have COVID-19 symptoms. The claimant had recently cleaned an office in which an individual had COVID-19. The claimant followed guidelines from health officials and began quarantine. The employer collected the claimant's equipment during his quarantine and did not respond to the claimant when he ended. Since the claimant's separation was as a result of the pandemic, he should be qualified for benefits and the employer's accounts protected from charge. Reverse AT, no voluntary leaving, no chargeback, disaster.
Agree with that. We should modify the appeal tribunal decision because the claimant stopped working due to experiencing symptoms of COVID-19 and was complying with health and safety guidelines by choosing to quarantine. The claimant should be qualified for the receipt of benefits and the employer's account protected from charge. Modify the AT decision, no voluntary leaving, no chargebacks caused by disaster.
Modify the AT, no misconduct, no chargeback, disaster.
All right. Majority vote is granting benefits to the claimant and protecting the employer's account based on disaster rationale. Commissioner or Chairman Daniel, the majority vote is under 045 as a voluntary leaving. Do you wish to short form dissent because your vote differs from the majority?
No,
Okay, then I'll count it as a unanimous vote.
fair.
Thank you very much, sir.
Case number 2628828, Commissioner Alvarez.
The decision is not supportable. Regardless of any contract what the employer may have with the general contractor, it was the employer's responsibility to provide safe work environment for its employees. The restroom facilities lacked toilet paper, infrequently cleaned, and they lacked hand washing stations. These working conditions were unsanitary and unsafe prior to the pandemic, and even more so taking into consideration the pandemic. The claimant complained, and the employer made it apparent that it did not consider itself to have any responsibilities for safety and sanitation of its work site. Therefore, the claimant had good cause connected with the work for quitting. Reverse AT, no voluntary leaving chargeback.
We should modify the appeal tribunal decision. The evidence indicates that the general contractor may not have applied the required health and safety guidelines and that the employer may have experienced shortages of PPE. Under these circumstances, the claimant's work-related reason for quitting was urgent, compelling, and necessary, so as to make the separation involuntary under section 207.046A1 of the Act. Accordingly, we should modify the AT decision. No voluntary leaving, no chargeback. Separation was urgent, compelling, and necessary.
I concur with Commissioner Dennison.
Commissioner
I would agree
Alvarez?
with Ms. Miller. I would also agree to urgent and compelling.
Very well, thank you. We have a unanimous decision.
Case number 2647068, Commissioner Dimerson.
The AT decision should be reversed. There are numerous job separation circumstances that function as an exception to disqualification from employment benefits. Such an exception exists for an individual leaving work because of a medically verified illness of the individual or the individual's minor child. Here, there is evidence that the claimant resigned due to medical illness, and for that, the claimant should be afforded an exception to being disqualified from benefits. However, being excused from disqualification and having good cause connected with work or quitting are two different concepts. In the case before us, the claimant is excused from disqualification because of her illness-connected resignation. However, because the reason for resignation is not connected with work, it cannot be used as the basis of having good cause to quit the job as it relates to billing the employer. Since section 205.0125 of the Act protects reimbursing employers from being billed due to job separations that were voluntary quits without work-connected good cause, the employer should not be billed. We should reverse the AT decision, reimburse an employer, not billed.
The decision should be affirmed. The claimant resigned due to her own personal illness, which is not a disqualifying separation. As such, the employer should be billed. Affirm the AT bill reimbursing employer.
Reverse the AT, reimbursing employer, not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2690038, Commissioner Dimerson.
The commission should grant a rehearing in this case. In its appeal to the commission, the employer stated that its supervisor is now available to testify and can provide relevant information that controverts the claimant's testimony. The employer also presents several documents that relate to the claimant's job performance that should be admitted into the record and reviewed before rendering a decision. Accordingly, we should conduct a rehearing for the employer's supervisor, witness, and documentary evidence.
The decision should be affirmed. The employer argued that the claimant was discharged due to attendance issues and not completing training. Despite instructions in the hearing packet explaining the need for witnesses, the employer chose not to present any firsthand witnesses to support their allegations. The claimant credibly testified that he completed the required training and that he did not have attendance issues. As the employer failed to present sufficient evidence of misconduct, the claimant should remain qualified for benefits. Additionally, the employer has not provided an adequate reason for rehearing. Affirm the AT, no misconduct, chargeback.
I would agree to rehear.
We will rehear the case.
Case number 2695872, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant asserts that she quit her job due to unfair treatment and bullying by her supervisor. However, the claimant's testimony did not contain any specific examples of an intolerable working environment. Furthermore, the HR director credibly testified that she performed a thorough investigation into the claimant's past complaints, and the claimant notified HR that everything was fine. This shows that the employer was willing to address the claimant's concerns, but the claimant put the employer on notice that her prior issues were resolved. Thus, when the claimant felt discriminated against during the final incident, she quit without good cause because she failed to afford the employer an opportunity to address her latest concern. Moreover, the precedent case cited by the AT references a claimant having good cause to quit after the employer fails to resolve legitimate complaints. However, the claimant's complaints reflect more of a personality conflict and not a hostile working environment. We should therefore reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant's supervisor regularly bullied the claimant and other coworkers. The claimant complained to HR, and HR investigated the issue but took no action. The supervisor's behavior continued until the claimant was given a reprimand for issues that other employees also had but were not reprimanded for. The claimant was subjected to a hostile work environment and took reasonable steps to resolve the problems without success. She therefore quit with good cause connected with the work. Affirm the AT, no voluntary leaving, chargeback.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
I have your dissent, Commissioner Alvarez.
Case number 2703359, Commissioner Dimerson.
The commission should grant a rehearing in this case. The employer stated that the claimant could have continued working for the employer, but would have needed to work from a different location further from her home. Details should be further developed before we render a decision. First, whether the employer or the claimant initiated the request to move the claimant to a different work location. Second, the employer should be asked how much further the claimant's commute would have been had she elected to continue working with the employer. Both points are critical in determining whether the claimant had good cause to quit and consequently whether the employer's account should be charged. Accordingly, we should rehear the case for the reasons so stated.
The AT decision should be affirmed. The claimant was transferred to a different organization and different employer account number because the employer needed to reorganize its locations and organizations. She was thereby separated from her employment with the employer. Commission President has long held that an employer is subject to chargeback when the employer initiates an employee transfer from one employer account to a different employer account under the same management. That is what happened in this case. Affirm the AT, charge the employer's account.
Reverse the AT, no chargeback.
I agree with the chairman.
Short form dissent.
Commissioner Alvarez, I have your dissent. And that is the last case pulled for additional discussion on docket 1. I sent the short form dissent list for UI cases on docket 1 earlier in the meeting.
I move we accept staff recommendations on the remaining UI cases on docket 1.
Chairman, I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 1.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 1.
Motion passes with the exceptions noted.
Thank you very much, and Happy New Year, gentlemen. Good to see you
Thank
again.
you. Happy New Year.
Hearing team, well done.
Happy New Year, Ms. Miller, and Ms. Gonzalez did a great job today.
Well
Thank
done.
you.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for a few moments to reset the rest of the meeting.
right, I'll see you guys. Chairman, we have a good conversation on F1, Formula One. I'm watching the document.
Oh, there you go.
On that, so
Yeah.
retire the car, retire the car. You gotta fit the car.
All right, are we ready to tackle the rest of this?
Let's rock and roll.
Let's jump in. This is agenda item 8, discussion, consideration, and possible action regarding the acceptance of pledges for board contract year 2020 and 2021 childcare matching funds.
Good morning and happy new year, Chair Daniel, Commissioners, Mr. Cerna. For the record, Jen Troke, Workforce Development Division. Annually, local workforce development boards submit local match pledges to secure federal child care funds pursuant to Commission Rule 809.17. This is a standing agenda item as boards may continue to submit match agreements through January 31st, 2021. Today's agenda includes 61 match agreements from 12 boards. 20 boards have secured a portion of match, with 19 securing at least 50% of their total. Today, staff requests Commission acceptance of child care pledges for donations, transfers, and certifications of expense for BCY 21 in the amount of $20,765,074. Happy to answer any questions, and thank you.
Any comments or questions?
None here, Chairman.
We have a motion on this issue.
I move that we accept child care match in the amount of $20,765,074 for board contract year 2021.
Second.
Yeah, it's been moved and seconded. We're unanimous.
Thank you.
Thank you. This will bring us to item 9, discussion, consideration, and possible action regarding adoption of amendments to 40 Texas Administrative Code, Chapter 800, General Administration, to implement Senate Bill 1055 from the 86 Texas Legislature relating to workforce diploma pilot program previously published for public comment in the October 23rd issue of the Texas Register.
Good morning, Chairman Daniel. How's the volume?
Good.
Okay, thank you. Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, Carrie Ballast with the Workforce Development Division. Commissioners, before you today for your consideration for adoption are final rule amendments to Chapter 800, General Administration. In open meetings on October 6, 2020, the Commission approved proposed amendments to TWC's Chapter 800 rules regarding the implementation of a workforce diploma pilot program under Texas Labor Code, Chapter 317. The proposed rule amendments were published in the October 23rd, 2020 issue of the Texas Register for a 30-day comment period. TWC did not receive comments on the proposed rules. Therefore, the final rules include no changes. Staff seeks Commission action regarding the adoption of the Chapter 800 rule amendment as included in today's meeting notebook and published on the agency's website. Should the Commission adopt these rules, staff requests the ability to make minor, non-substantive changes to the document in order to comply with publication requirements of the Texas Register and of the Secretary of State office. This concludes my presentation. I'm available to answer any questions that you may have. Thank you.
Thank you. Any comments or questions?
None here, Chairman.
Good to see it getting done. No other comments.
We do have a motion here.
Chairman, I move that we adopt the Chapter 800 rules related to the Workforce Diploma Reimbursement Program as discussed by staff.
Second.
Been moved and seconded. We're unanimous.
Thank you.
Thank you. This is item 10, discussion, consideration, and possible action regarding adoption of amendments to 40 Tech Chapter 803 Skills Development Fund relating to the implementation of House Bill 108, 80 Texas Legislature, House Bill 700, 86 Texas Legislature, previously published for public comment in the November 13th, 2020 issue of the Texas Register.
Good morning, Chairman Daniel, Commissioner Alvarez, and Commissioner Dimerson, and Mr. Cerna, and Happy New Year. For the record, Christina Ramos with the Workforce Development Division. Commissioners, before you today for your consideration for adoption are final rule amendments to Chapter 803 Skills Development Fund. In open meeting on October 29, 2020, Commission approved proposed amendments to TWC's Chapter 803 rules in response to changes passed in House Bill 700 during the 85th legislative session. Specifically, these changes include amending Section 803.1A to add boards to the list of eligible entities to provide customized assessment and training. Amending 803.2 to update definitions to include boards as eligible partners and grant recipients. Amending Section 803.14 to remove the requirement that boards review and comments on SDF applications submitted to TWC and to include boards and other provisions of the procedure for requesting funding. Amending Section 803.15 to remove the requirement that TWC notify boards when evaluating an SDF application, instead requiring that TWC notify all eligible applicants when it is evaluating an SDF application. And to add Section 803.15, which will prohibit SDF applicants on corrective action as described in Chapter 802, Subchapter 3, corrective actions from receiving an SDF grant. Additionally, House Bill 108, which passed during the 85th legislature, amended to the Labor Code regarding the use of grant funds to encourage employer expansion and recruitment. We are proposing amending Section 803.4 to incorporate this change. There are also some minor changes correcting the name of the Texas A&M Engineering Extension Service to include A&M, and some technical changes updating outdated references in rule. Lastly, there was a change to Section 803.2 definitions to remove any reference to individual or person from the definition of private partner. The proposed rules amendments were published in the November 13, 2020 issue of the Texas Register for a 30-day public comment period. 2 public comments were received. Staff has reviewed and responded to the comments, and as a result of those comments has modified the proposed rules. These changes include changes to Section 803.2 definitions in response to comments received. Definitions are added for eligible applicant and executive director to clarify the use of these terms in proposed Section 803.14. Section 803.14 is amended to clarify the language stating that SDF applicants obtain the review and comments of the board in the applicable workforce area where there is a significant impact on job creation or incumbent worker training. Comments were received from 2 entities regarding board comments and review of skills applications. A review of proposed language submitted by 1 commenter resulted in the changes to 803.14 that are before you today. Specifically, that applicants will request the review and comments of the board in the applicable workforce area where there is a significant impact on job creation or incumbent worker training. An eligible applicant is not required to obtain or provide comments if the board informs the applicant that the board is preparing an application or has submitted an application that has not been approved or rejected. Boards are not required to comment on their own applications. And eligible applicants shall submit any updates to the original application for funding in accordance with previously mentioned sections. Staff seeks commission action regarding the adoption of the Chapter 803 rule amendments as included in today's meeting notebook and published on the agency's website. Should the commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm available to answer any questions that you may have. Thank you.
Thank you. Comments or questions?
I have a comment, Chairman.
Mhm.
Ms. Ramos, first of all, Happy New Year to you as well. So thank you for that. And thank you for working so closely with our office. I do want to state for the record my following comment. And I also want to make it clear, I just specifically want to ask this question for clarification purposes. As you know, the modified comments for the agenda items are for agenda item 10 has been given to all of us. I would like to thank Taub and Blinn College for their comments to the posted rules. I was glad to see the changes to the rules and believe they now better reflect the type of collaboration we want to encourage between the boards and the community colleges to develop training projects that support local employers while upskilling upskilling workers. However, I am concerned that we did not take the opportunity to clarify the statute by indicating that public state colleges are eligible participants for skill grants. Although historically we have allowed public state colleges to be eligible applicants, the rule does not list them as an eligible grantee. I noted this during the work session on these rules in the past and did not receive any clarification. This is a missed opportunity. Again, I want to thank you, Ms. Ramos, for this, but again, I understand the conversations that we've had in the past, and I understand that there's a distinction between dual enrollment, but for the record, I'd like for that to be stated during this work session or during this time.
Additional questions or comments?
Mr. Chairman, I'd like to also thank Christina and the team for the work that they've done. Thank you for the patience as well. And thanks for just simply getting it done. Also, I'd like to applaud those boards that are out there in the colleges for the work that they've done in the past and the work that they're going to do in the future. So I'm excited about what we have before us and looking forward to jumping right in.
All right, do we have a motion on this issue?
I guess, are we clear on the state colleges? That was my main concern. And I didn't know if Ms. Ramos wanted to respond to that, my comments.
Commissioner Alvarez, I did speak with your staff, and because the change was not in response, was not a direct response to any of the comments that were received during publication in the Texas Register, we did not address that change at this time. If we were to make the change, we would be required to republish the rules in the Texas Register for another 30 days for public comment and then bring them back to the commission for vote.
So is it safe by saying that those state colleges that have been awarded in the past, like the LITs, would continue receiving skills development grants?
Yes, because they are identified in the statute as eligible recipients.
Perfect. I wanted that for the record.
Sure.
Nothing else here as far as comments. I'm ready for the motion.
Okay.
I move that we adopt the amendments to Chapter 803 Skills Development Fund as presented.
Second the motion.
It's been moved and seconded. Motion carries.
Thank you, Ms. Ramos.
Thank you.
This will bring us to agenda item 11, discussion consideration possible action regarding adoption of amendments to 40 Tech Chapter 806, purchasing from people with disabilities, relating to the implementation of Senate Bill 753-86 Legislature and PPD program improvements previously published for public comment in the November 27th, 2020 issue of the Texas Register.
Good morning, Chair Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, I'm Michael Hooks with the Vocational Rehabilitation Division. Today for your consideration are for adoption or final rule amendments to Chapter 806 with the purchases of products and services from people with disabilities. In an open meeting November 10th of 2020, the Commission approved proposed amendments to TWC's Chapter 806 rules regarding the PPD program. The proposed rule amendments were published in the November 27th, 2020 issue of the Texas Register for a 30-day public comment period. Public comments were received. Staff has reviewed and responded to all comments. As a result of those comments, has modified to clarify the proposed rules. There were 3 comments received regarding a third-party disability determination methodology. Clarifications are proposed to address those concerns presented. Staff seeks the Commission's action regarding the adoption of Chapter 806 rule amendments as included in today's meeting notebook and published on the agency's website. Should the Commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm available to answer any questions that you may have.
Any questions or comments?
None here, Chairman.
No questions. I want to thank Mike for briefing our offices again, the initial briefing. So thank you, Mike, for that.
Do we have a motion?
Yes, sir. I move that we approve the changes to Chapter 806 rules as discussed by staff.
Second.
It's been moved and seconded. Motion carries. This is item 12, discussion, consideration, possible action regarding an appointment to fill a vacancy on the advisory committee of the Purchasing People with Disabilities Program.
Looks good. Good morning. For the record, I'm Michael Hicks with the Vocational Rehabilitation Services Division. The Texas Resources Code, Section 122.057A, authorizes the Commission to establish an advisory committee to assist the Commission in establishing program performance goals and criteria for certifying community rehabilitation programs, or CRPs, with the Purchase from People with Disabilities Program. For 122.0057, the advisory committee is composed of 13 members as follows. 4 representatives from CRPs that participate in the program, 4 from organizations that advocate for individuals with disabilities, the executive commissioner of the Texas Health and Human Services Commission, or their designee, and 4 individuals with disabilities who, of which 2 are employed by a CRP that participates in the program. The committee has a current vacancy in the individuals with disabilities category. Specifically, a vacancy is the one for the one of the 2 seats held by individuals with disabilities not working for a community rehabilitation program. 2 individuals applied for the vacancy, both of whom meet the criteria for consideration. Staff has reviewed the candidate's stated qualifications and experience serving on boards and committees and supports the appointment of the candidate with experience serving on boards and committees. Staff seeks direction on the appointment of Ms. Kathy Williams to the PPD Advisory Committee for a standard 4-year term in the category of people with disabilities not working for a CRP. That concludes my presentation, and I'm open to any questions you may have.
Any questions or comments?
Chairman, the comment I have is I want to thank Mr. Hooks for the work they've put together. It was my understanding that we had 2 great applicants that had applied for this position. So I just wanted to take the opportunity to congratulate Ms. Williams. But Mr. Hooks, thank you. I know they were equally qualified, and it's good to see that we have folks like that are interested in volunteering their time to serve in this capacity. So thank you for that.
Chairman, I too would like to congratulate Kathy Williams, if accepted, in this appointment for this PPD Advisory Committee.
All right. Do we have a motion on this issue?
Chairman, I move that we appoint Kathy Williams of Austin to the PPD Advisory Committee for a 4-year term in the category of people with disabilities not working for a CRP, as discussed by staff.
Second the motion.
It's been moved and seconded, and we're unanimous. Move to item 13, discussion, consideration, and possible action regarding adoption of amendments to 40 Tech Chapter 823, Integrated Complaints, Hearings, and Appeals, previously published for public comment in the October 23rd, 2020 issue of the Texas Register.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Chris Oakley with the Unemployment Insurance Division. For your consideration and possible adoption this morning are the Chapter 823 rules, Integrated Complaints, Hearings, and Appeals. As a recap, these rules provide an appeals process for complaints or determinations regarding federal or state-funded workforce services administered by the TWC or local workforce development boards. The rule amendments clarify the parties and programs covered by the rules, align the rules with the Workforce Innovation and Opportunity Act, clarify terminology between local and state level hearings and appeals, and add provisions to the rules for appealing state level decisions to the U.S. Secretary of Labor. The proposed rules amending Chapter 823 were approved by the Commission on October the 6th, published in the Texas Register on October 23rd for a 30-day public comment period, and no comments were received. Therefore, the final rules contain no changes. If adopted, staff also requests the ability to make minor non-substantive changes in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my remarks, and I'm happy to answer any questions you may have.
Any questions or comments?
None here, Chairman.
None.
And do we have a motion here?
Yes, sir. I move that we adopt the Chapter 823 rules relating to the integrated complaints, hearings, and appeals as discussed by staff.
Second.
It's been moved and seconded, and we're unanimous.
Thank y'all.
Thank you, Mr. Oakley.
Move to agenda item 14, discussion, consideration, and possible action regarding the adoption of the rule reviews of 40 Tac Chapter 804, Education for Texans, 40 Tac Chapter 807, Career Schools and Colleges, and 40 Tac Chapter 858, Procurement and Contract Management Requirements for Purchase of Goods and Services for VR Services. This was previously published for the public comment in the July 17, 2020 issue of the Texas Register.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I'm Reed O'Brien with the Office of General Counsel. The Texas Government Code, Section 2001.039, requires state agencies to review their rules every 4 years and determine if the initial reasons for adopting the rules continue to exist. Before you today for your consideration are 3 chapters for readoption. Chapter 804, Jobs and Education for Texas Grant Program, Chapter 807, Career Schools and Colleges, and Chapter 858, Procurement and Contract Management Requirements for Purchase of Goods and Services for Vocational Rehabilitation Services. In an open meeting on June 30th, 2020, the proposed rule reviews were approved for publication in the Texas Register for a 30-day public comment period. The proposed rule reviews were published in the July 17th, 2020 issue of the Texas Register, and no comments were received. Staff has reviewed each of these rule chapters and determined that the initial reasons for adopting the chapters still exist, and these chapters are still needed. In accordance with the requirements of Texas Government Code Section 2001.039, staff seeks commission action to readopt chapters 804, 807, and 858 as included in today's meeting notebook and published on the agency's website. This concludes my presentation, and I'm available for any questions.
Any questions or comments?
No questions for Mr. O'Brien.
None here. Thank you.
Do we have a motion on this issue?
Chairman, I move that we readopt chapters 804, 807, and 858 as discussed.
Second.
Then we're second and we're unanimous. Thank you. This is item 15, discussion, consideration, possible action regarding adoption of amendments to 40 Tac Chapter 809 Childcare Services, previously published for public comment in the October 23rd, 2020 issue of the Texas Register.
Good morning, Chairman, Commissioner, and Mr. Cerna. For the record, Allison Wilson with the Childcare and Early Learning Division. Today, we bring forward the final rule amendments to TWC's Chapter 809 Childcare Services rules for your consideration for adoption. In an open meeting on October 6, 2020, the Commission approved proposed amendments to Chapter 809 regarding requirements arising from the passage of House Bill 680 during the 86th legislative session, amendments that align with the Texas Rising Star 4-year review, as well as a few other updates and technical corrections. The proposed rule amendments were published in the October 23rd issue of the Texas Register and were available for public comment until December 7th. TWC received many public comments, which staff has reviewed and responded to in the final rule preamble. As a result of these comments, staff has modified the proposed rules to clarify policy intent for 2 sections. We modified Section 809.16 to clarify that boards maintain flexibility on how to spend their 2% quality funds, and we modified 809.19 to clarify that if a parent receives a discounted parent copay for selecting part-time care but later switches to full-time care, the originally assessed parent copay will be applied. Staff seeks direction regarding the adoption of the Chapter 809 rule amendments as included in today's meeting notebook and published on the agency's website. Should the Commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. And this concludes my remarks on this item, and I'm happy to answer any questions you have.
Any questions or comments?
No questions for Ms. Wilson.
Chairman, I just continue, Allison, appreciate you guys working with the stakeholders in terms of developing all of this. Just appreciate getting that feedback.
Is there a motion?
I move that we adopt Chapter 809 rule amendments and the new sections relating to childcare services as discussed by staff.
Second.
Been moved and seconded. We're unanimous. Thank you. This is agenda item 16, discussion, consideration, and possible action regarding the implementation timeline and protocols for the Texas Rising Star 4-year review revisions.
Okay, again, Allison Wilson with the Childcare and Early Learning Division. On January 21st, 2020, the Commission approved the publication of a set of recommendations on Texas Rising Star. These recommendations were based on the input of the Texas Rising Star Work Group and included the Chapter 809 rule changes just approved, as well as recommendations for a statewide transition timeline to allow Texas Rising Star staff and currently certified programs time to become familiar with and plan for the changes. TWC must consider the impact to childcare provider assessments and in-person visits during the time that Texas Rising Star staff are transitioning to and learning about the new standards. The ongoing COVID-19 pandemic has also impacted assessments and in-person visits leading up to the implementation of the revisions and must be considered as well in the transition. Staff seeks direction on requiring all Texas Rising Star assessors to pass the assessor trainings and attain their required certification by the rollout date for the new Texas Rising Star standards, currently scheduled for April 1st, 2021. Allowing 2-star structural assessments to continue against the current standards during this month, January 2021, and deferring all other assessments from February through March and prioritizing assessments under the revised rules as described in the discussion paper. And this concludes my remarks on this item, and I'm happy to answer any questions you have.
Any comments or questions?
None here, Chairman.
None.
We have a motion here.
I move that we approve the TRS implementation plan as presented by staff.
Second.
Been moved and seconded. We're unanimous. Agenda item 17 and postponed to a future meeting. Agenda item 18, discussion consideration, possible action regarding an individual request to waive the child care services rules under 40 TAC Chapter 809.3A regarding Texas Rising Star minimum education requirements and 40 TAC Chapter 809.134.
And once again, Allison Wilson with Childcare and Early Learning. TWC's childcare rules, section 809.3, allow any person directly impacted by the rules to request that the commission waive its rules. A Texas Rising Star mentor has submitted a request to waive the childcare rules under this provision. Specifically, this individual has requested that the commission waive section 809.134, which establishes the minimum education requirement for Texas Rising Star staff. In the individual's letter to the commission, she notes that she is submitting this request so she may maintain her position as a Texas Rising Star mentor while continuing to work toward the completion of her associate's degree in early childhood education. This individual was already provided with a 2-year extension as authorized under 809.134 to allow her to complete an additional 60 hours for her required education. Based on staff's review of the mentor's college transcript, during 18 months, she only accrued 9 college credit hours and was not on track to complete her degree within the 2-year time frame. The board has expressed concern regarding the length of time this waiver request has taken to consider. They noted that they needed sufficient time to issue a request for proposals and enter into a contract for a new mentor should this waiver not be granted. The Childcare and Early Learning team has established new internal controls to ensure that any requests that are submitted henceforth are processed internally on a timely basis. We're also instituting changes to ensure that any future request for an extension of educational requirements includes a plan noting how the individual will meet the educational requirements within the extension timeframe. Boards will also be required to monitor the educational progress of staff granted extensions and to notify us if the education plan needs to be modified. For this individual's request, staff recommends that in order to provide the board with time to procure and contract for a new mentor, the commission grant a temporary 4-month waiver to allow the individual to continue serving as a Texas Rising Star mentor. And that concludes my remarks. I'm happy to answer any questions.
Any comments or questions?
No questions, but I do have a comment, Chairman.
Mm-hmm.
This individual has already been granted a 2-year exemption to meet the educational requirements. At no point was she taking classes at a rate that would enable her to comply with Rule 134 within a 2-year period. A similar waiver request was made a couple of months ago by an individual employed by a different board. The board is responsible for finding qualified staff and complying with the program rules. It is the board's obligation to monitor its staff and contractors to ensure compliance with the rules. The board should have acted to find a qualified replacement when it became apparent that the individual would not be able to meet the educational requirements, instead of waiting for a special exemption to be made. While I am reluctantly supporting this extreme limited waiver today, moving forward, I expect boards to comply with the rules and maintain qualified staff.
Other questions or comments?
None here.
Do we have a motion here?
Yes, I move that we grant this individual a temporary 4-month waiver of educational requirements of 40 TAC 809.134.
Second.
I want to be shown as voting no. I actually agree with Commissioner Alvarez's concerns. I think there were mistakes all the way around. I understand Commissioner Alvarez's position and his desire to move things forward, but I think he hit the nail right on the head in terms of management and understanding how these things work. It's a regrettable situation all the way around, I think. And well, there, I've said my piece, but I think we have a majority vote here. Is that correct, gentlemen?
Right.
Motion carries.
Thank you, Chairman.
This is agenda item 19, 2020 TWC annual report, discussion, consideration, possible action on the submission of the 2020 Texas Workforce Commission annual report to the governor, the legislature pursuant to section 1.065.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Margaret Hessian, Director of Communications. You have before you TWC's 2020 annual report to the governor and Texas legislature for your consideration and approval. I am requesting your approval of the TWC 2020 annual report with your permission to make any technical corrections or further revisions today as necessary. I'm also prepared to answer any questions, receive further edits or direction you have at this time. Thank you.
Any comments or questions?
I have comments, Chairman.
Yeah.
Chairman, I just wanted to thank my fellow commissioners, staff, Margaret, Cisco, Tom, everyone on the team for putting such a great report together. As you know, we use this report as we meet with legislators so that they can be updated on some of the successes the agency has had, and of course, some of the challenges that we face. So I just wanted to take this opportunity to thank everyone for their input and the information that was actually, it's up-to-date information that was actually put in the report. So thank you for that.
Thank you.
Margaret, good job. And I have a few things on here, but they're not anything that we need to discuss out loud. They're not anything substantive at all. So, good job.
Thank you.
I have a couple things. So the numerical data in pages 2 through 4, we might want to consider a more logical end date to that. At this point, we have data through the end of the calendar year that might provide a fuller picture of what's been going on here rather than the end of the fiscal year. Take a look at that and see if that's uncomplicating. I would encourage us to use just a little more logical end date on the data. I did note some typographical errors throughout the report. I'm confident that you guys will find those and iron those out before this is finalized and published. On page 54, the trust fund chart, I think there's a 2 missing in the revenues for FY 2020, which puts the math off by about $20 million. We might fix that before we go to final publication.
Thank you, Chairman. And we will make those typographical error revisions on page 54. And then with respect to pages 2 to 4 on the data, my understanding is we're going to run it to the end of the calendar year as opposed to the fiscal year already ending November 7th. It currently ends on right now.
Okay. Any additional comments or questions?
Chairman, good points. And I also agree with the recommendations you made.
Thank you. Do you have a motion here?
I move that we approve the 2020 TWC annual report for submission to the governor and legislature.
Second.
I agree. So we're unanimous. Thank you.
Thank you, commissioners.
I'm showing that staff does not have anything under agenda item 20. Do we have anything under agenda item 21, Mr. Cerna?
Yes, sir. We've got 3 updates for you from Clay and then Reagan and Cheryl.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerner. For the record, Clay Cole, Unemployment Insurance Division. And happy 2021. I'm going to give you a quick UI update. UI is working hard and strategically with IT and external relations on implementing the Continuous Assistance Act changes and customer outreach tasks. Over the weekend, teams modified over 1.1 million current active benefit claims, allowing customers to begin transitioning to the new extensions. And please note, we began issuing federal pandemic unemployment compensation payments, the FPUP payments yesterday, and paid out over 44 million in the first 2 days. And this is the $300 per week payment alone. We do have roughly 140,000 claimants that exhausted benefits between October and December that we are working on transitioning over to benefits to benefit from the extensions, which requires additional attention because of the potential employment and decisions required in between the gap of the last payment and December 27th, 2020, when the Continuous Assistance Act began. We hope to have these claims updated in the coming weeks. That is really our priority now, is to get those individuals transitioned over that are eligible. Granted, there will be some of those that have returned to work and may not still be unemployed. And so we're working through those as soon as possible. Reminder, January is always one of our busiest months for all call centers, being because it's a change of quarter month, and also our 1099 distribution. This year we'll be distributing 2.93 million 1099s to claimants this January. Texas did finalize the agreement with the Department of Labor for the new Mixed Earners Unemployment Compensation Program last week. We're still awaiting guidance from the Department of Labor regarding the requirements of this completely new program that provides an additional $100 per week for individuals on regular or pandemic emergency unemployment compensation benefits, not PUA. I want to make this clear. Individuals on pandemic unemployment assistance are not eligible. It's just the regular type programs. These individuals will need to provide self-employment proof of a separate job with earnings of 5,000 or more for an annual period. And there's more information to come on this. Right now, we don't have a timetable exactly when this will be implemented. We're working with IT and also still awaiting guidance. And we'll be coming back to you with an update as soon as possible. UI teams are working on scheduling briefings the next couple of weeks to lay out plans on a couple UI tax rate components that the commission has discretion to discuss and set. We plan to bring forth the discussion paper as early as January 19th, 2021, but we'll be meeting with you in the coming weeks as early as this week. Finally, I also want to just thank all our volunteers, both inside and outside the division, who have helped us serve so many customers. Without their help, these milestones would not have been reached, and thousands of Texans could not have been provided assistance. It's with this kind of teamwork that TWC and the citizens of Texas will overcome this pandemic. And this concludes my update, and I'll be happy to answer any questions you might have.
Any questions?
I just wanted to take this opportunity to thank Clay. He's heard this in the past. Clay, I'm going to take this opportunity. As you know, I think we're all in agreement that we wanted to extend our sincere thanks to you and your team, those individuals that are answering phone calls every day of the week, with the exception of Thanksgiving. I think it's important that we disseminate that information to the folks listening in. We work really hard, and we have challenges that we come across all the time. I think your team, I think what the agency has done to address those concerns is certainly relevant, and I think we've done a really good job. We continue to improve. We learned from the first phase, so thank you for that. The information that you provide to the offices on a daily basis is certainly it's great information, and that's information that we're able to share with our constituents as we talk to them. Nothing's perfect, but we try our very best. So thank you for that. And I just wanted to take this opportunity, and I think like I said, we're all in agreement that the volunteers that you referenced, those individuals that answer the calls on a daily basis, working evenings and weekends when many people are off, we can't let them go unnoticed. That the agency has done a really good job. And then of course, IT and all the other things. So thank you for providing us with updates and working so closely with the other directors and our executive directors and keeping our offices informed of any changes and updates. So thank you. I just wanted to take this opportunity.
You're welcome, Commissioner Alvarez. Thank you.
Chairman, I'd like to also concur with Commissioner Alvarez, Clay, Lachey, Chris, that entire team. You guys are knocking it out. And of course, at the top. And so, Ed, thank you for what you're doing in that regard. And so I want to overemphasize, and you guys have heard me say this over and over, but over communicate is the goal. I think there's not any opportunity that we don't take advantage of to make sure that we're communicating the word out, because I'm referring folks to our website, I'm referring them to different things, and I'm telling them that our agency will be communicating with them on an ongoing basis. And so that's my message, over communicating, because when the information's out there, we all succeed in that regard. But good job thus far.
Thank you.
All right, other questions or comments? Great.
We have Reagan Miller for childcare update.
Thanks, Ed, and good morning, Chairman and Commissioners. Reagan Miller with the Childcare and Early Learning Division, and today I want to provide you with an update on some recently enacted federal legislation that included a significant increase in COVID-related funding for the Child Care Development Block Grant. This legislation did include $10 billion in CCDBG funds. And while the Administration for Children and Families Office of Child Care has not yet released the official state-by-state allotment amounts, a national child care organization has developed their own estimates, noting that Texas should receive just over $1 billion. In a call yesterday, the Office of Child Care said that they would be issuing guidance to the states very soon. States are required to submit a planned use of funds report within 60 days of the enactment of the legislation. So we should have a plan due around February the 25th. The Office of Child Care did note that these are very flexible funds intended to help states address the impacts of child care, but there are a few specific requirements in the legislation that I did want to highlight. First, there are non-supplantation provisions. Second, we must use a portion of the funds to support all regulated child care providers, not just those who have historically participated in the subsidy system. These funds are for the purposes of cleaning and sanitation and other activities necessary to maintain or resume the operations of programs, including for fixed costs and increased operating expenses. And finally, we must widely publicize and provide technical assistance on how we will make these funds available to support the stability of the child care sector to offset increased operating expenses. I did want to point out that as of the end of December, we had over 14,000 regulated open child care providers. So as we're considering our implementation strategies, we need to be mindful of the impact of the workload and the heavy lift that we'll have to undertake to enter into these types of contractual agreements with 14,000 entities across the state. We'll say that we have until September 30th, 2022 to obligate the funds, and then we have another year until September 20th, 2023 to spend the funds. Of course, we'll be working closely with each of your offices as we develop strategies around the proposed uses of these funds. So those are my updates for today.
Thank you. Any questions or comments?
No, thank you, Reagan, for keeping the offices so briefed on and updated on the information. I know it changes every day because I know you're having conversations every day. And thank you for working so closely with our child care providers and for what you do. And again, for sometimes thinking outside the box and some of the initiatives that you put forth. I thought I'd take this opportunity to thank you for that. And
yes, sir.
Keep up the great work. Keep up the great work.
Reagan, it'll be a heavy lift there. Are there any administrative dollars tied to that billion that's coming out?
In the legislation, the 5% administrative cap remains, but all of the other set-asides are not there. So the funds are really available to the state to budget in whatever way they feel best to meet their needs. But that 5% admin limitation remains in place.
Okay, all right, sounds good, thanks.
Yes.
All right, thank you so much.
And then one final update from Cheryl Fuller.
Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson. For the record, Cheryl Fuller, Vocational Rehabilitation Division. This morning, I also would like to provide a brief update on recently passed federal legislation. The Consolidated Appropriations Act of 2020, passed by Congress and subsequently signed by the President on December 27th, includes an appropriation of $20 million for the Randolph-Shepard program, which in Texas we call our Business Enterprises of Texas program. The purpose of this funding is one-time financial relief and restoration grants to blind vendors, our BET managers. Most of the details of how this funding will be distributed to states are pending as we await guidance from the Rehabilitation Services Administration and the U.S. Department of Education. But based on the language in the Appropriations Act, we do know the following. First is the funds can only go to vendors or BET managers that were operating BET facilities as of September 30th, 2019. As of that date, our BET program had 100 vendors. States must use this funding to make payments to offset losses of blind vendors that occurred during calendar year 2020, but only to the extent that those losses were not otherwise compensated. If there are funds remaining after these payments to vendors, states may use the funds for other purposes authorized under the federal regulations for the Randolph-Shepard program, but must make determinations about how to use that excess funding with the active participation of the State Committee of Blind Vendors, which we call our elected committee of managers. The funds are available to the Secretary until September 30th of this year, and I will keep you apprised as we receive guidance from RSA. That concludes my presentation, and I'd be happy to answer any questions.
Any questions?
And none at this time, Chairman.
No questions. Thank you. Thanks, Cheryl.
Thank you.
Thank you.
That's it for the updates under this agenda item, Mr. Chairman.
Thank you very much. Agenda item 22, discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Shante, you're muted.
Okay, can you hear me now?
Yes, ma'am.
Okay, thank you. Good morning and Happy New Year, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna. For the record, Shante Williams with the Workforce Development Division. And before you for consideration are Workforce Board nominations for Workforce Solutions Alamo and East Texas. And staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
Any questions or comments?
None here, Chairman.
And here.
Do we have a motion?
I move that we approve the board nominees for Alamo and East Texas.
I second the motion.
Been moved and seconded. We're unanimous. Thank you.
Thank you.
Let's see. Agenda item 23, legislative proposals. I don't think we have anything here.
No, sir, we don't have any thing under legislation, and I have nothing under Executive Director's report to be preempted.
Well, is there any other order of business that should come before the commission?
None from me, sir.
None? Well, again, Happy New Year to everyone. 2021 promises to be another interesting year starting out, but we've got a lot of initiatives in play and working. We've got some things on the horizon that we'll be working on. And so, you know, I envision another fairly active year in terms of us being innovative and how we can assist folks that are looking for a job, folks that are trying to improve their job, and certainly people that are upskilling, reskilling. I'm looking forward to bringing together our statewide workforce strategy into the conversation so that we can continue to talk about that. And so for all those that have wished us a Happy New Year today, Happy New Year to you, and Happy New Year to the folks who are watching at home. Commissioners, anything additional?
Chairman, I look forward to a great 2021 year with all of us, with everyone that's online, everyone that works for the agency. Take this opportunity to thank everyone for the great work that they've done. And I am truly blessed to work for a great agency like Texas Workforce Commission. So, and I'd also like to acknowledge that and congratulate, you know, Joel Mullins for the recent new position that he'll be having with the agency. I think he was a great selection, and I'm looking forward to continuing working with him in his new capacity.
Well, team, happy 2021. This is the year of the cow. And so all those in agriculture, that's something, Texas is a big ag state. So Chairman, you know a little bit about the ag industry there.
A little bit.
Happy 2021.
All right, do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
It's been moved and seconded to adjourn. It's unanimous and we're adjourned.
All right.
Have a good day,
Y'all have a
everyone.
great day.
Guys.